Wow, this is very loud. My name is Amy Wan. I'm the founder and CEO of Sagewise, which is a dispute resolution infrastructure for smart contracts. If anyone is interested in working in the industry, we are hiring. But we have a very interesting panel here today. I feel like normally when people talk about legal and regulation, everyone wants to go to sleep, and yet in this industry, it seems to be a super hot topic. So I am going to let our esteemed panelists do a quick intro of themselves. So just tell us your name, where you work, what work you've done in the blockchain industry, and then we have a lot of meat to dive into.
All right, let's start on that end. No, no, my name's Steve Masur. I'm a partner at a law firm called Masur Griffitts, MG+. And we are a technology firm, a law firm that serves technology companies. We've been doing it for about 25 years, and we have offices in New York and LA. And I'm just really excited to be working in the blockchain blockchain space. We're doing a lot of really interesting work around the definition of whether it's a security token or a utility token. And I have an interesting background having worked at the Securities and Exchange Commission and some insights to share about the way they think about it.
I'm Greg Gilman. I'm one of the founders of Science, which is a 6-year-old incubator and accelerator and venture fund in Santa Monica. We've funded or founded 95 or so businesses to this point, and had a few of them acquired for about $1.3 billion in aggregate, including Dollar Shave Club. We got involved in the blockchain space 5 years ago, and this past year we actually conducted our own token sale to fund a blockchain-only incubator. And we're now invested in probably somewhere between 100 and 200 ICOs over the last 12 months, and are actively incubating a number of companies currently.
It's a big number. Thanks for everybody coming out on a Saturday. My name is Adam Ettinger. I am a partner at the law firm of Sheppard Mullin. We are a small law firm of 750 attorneys and 15 offices. I run the blockchain group along with a colleague of mine, and we're involved in pretty much every aspect of what you guys are interested in. I started moving into this space in 2012, getting pulled in to do semiconductor development agreements in order to create mining equipment. And then, as with most people, mind blown, represent everything from, I guess, some of the stalwarts like BitGo, which does security and secure wallets and other technologies, to the leading edge stuff like, let me think, Lightning Labs, which is moving forward the Lightning Network protocol, and of course, token sales and everything else in between.
Hi, I'm Kelsey Lemaster. I'm a tax partner at the law firm Goodwin Procter. We're not quite as small as Sheppard Mullin, but we have about 1,000 lawyers. So I work in this space tangentially on the tax side. Our firm does a lot of work with companies engaging in ICOs, token sales, SAFT offerings, SAFT, SAFT, all kinds of crazy acronyms. Every week there's a new one. We have worked with a couple of funds that are working on doing their own token offerings, somewhat along the lines of Science, and we work with a number of hedge funds that are trading in the crypto space. So we advise both from the company side and the investor side on all aspects, but my specialty is tax.
So just so we can get a quick gauge of the level of blockchain expertise in this room, who feels like they don't know anything about blockchain? ICOs. Okay, a couple. Who is an investor? Oh, okay. Who has their own blockchain project? Okay, cool, good mix. So, for those who don't know too much about the space, one of the big debates we're having in the space, and it's not quite mutually exclusive, is, for a token, when it comes to all the law and regulation, that kind of stuff, is it a utility or security or both? And I know you had a specific opinion about that. Could you shed some light?
Yeah, I'm happy to talk about it a bit. So first we should talk about what a utility token would be. It would be a token that only really has a potential use in the business of the company that's offering it. And so I think everyone's going to agree with me if I say that many of the tokens that have been issued are seen by the SEC and by a lot of securities lawyers to be securities, or to be, and it could have utility and also be a security. So it's sort of not a switch that you flip either direction. It could be both. And it's going to depend on the attributes of the token. But my opinion is that the coins are actually a new asset class. And it's going to be very interesting. The reason is that they don't actually represent equity in the company. And that's not really part of the Howey test, but it does create a different dynamic, and the liquidity creates a different dynamic. And I would actually encourage anyone who is working in the area and thinking about these issues to reach out and tell the SEC what you think about it, because I think they're working really hard to try to figure out how they're going to deal with this. In the hearing that was last week, the SEC head and the CFTC head both discussed it, and they both were pretty clear that they didn't really claim that their agency had total jurisdiction over the area. Each of them said the same thing, and they both kind of said that we think we overlap and we think there's space in between. And so they're looking really to the legislature, they're looking to Congress to tell them what to do in the area. And so it's going to be really interesting from a regulatory perspective, but it creates a lot of uncertainty in the market, which is really bad because it means that a lot of companies will just choose to go offshore in order to avoid the uncertainty. So that's the overview of what's happening.
So, Greg, you are a very interesting person in this space because I think you...
Is that a compliment? Yeah.
Well, I think you might be the only attorney to have actually ever done your own ICO. Is that correct?
To the best of my knowledge, but I couldn't tell you for certain.
And you're also advising and incubating all these ICO projects. So where do you fall on the security versus utility debate?
Well, our token is a security. It was offered in the U.S. and internationally pursuant to exemptions from regulation or registration, and we did that deliberately. I think most tokens are in the future likely to become securities, or there is likely to be a much larger security token market in the future than there is currently once the alternative trading systems come online and there's actually a market for these digital assets. I think, building on what Steve said, I think there's sort of two ways or two elements of whether or not a token is a security. The first is whether it is actually a utility token in the system as he was describing, and then the second is, does it become a security by the way it was sold, right? Like you can have a utility token that you sell in a certain way so it becomes a security, which is why we've seen the market evolve away from sort of direct token sale model to usually to a future token agreement, whether it's a SAFT or any one of the other number of agreements that are out there now, sold to accredited investors as a security that then gets extinguished when the functioning utility tokens are delivered when the system is live.
Very interesting. Anything to add?
I think it's interesting because just an easy way to think about it is to think about trading cards, and I like to say Chuck E. Cheese tokens. If everyone's familiar with the video game place where you could play video games, the Chuck E. Cheese token could be used inside the store to play Galaga and Asteroids, or you could take it out in the parking lot and sell it and trade it for anything you want. And so this ability to sell it is why the SEC thinks of it as a security, I think.
Well, just to back it up, so one common definition of a security token is almost identical to what the Swiss regulatory body, how they worded it this week, which is that it provides access to a particular platform. It might be something that looks like a vending token that allows you to then listen to your favorite tune. And that's what we're seeing most of the ICOs position their token. There is no, under at least US securities law and any other securities law, there's no such thing as a security token under the law. What it is that recently on December 11th, the SEC came out with what's called the Munchie Order. They basically stopped or asked an ICO to stop because they said that they did a number of things, quite a few things that weren't fraudulent. They weren't lying, they weren't trying to scam anybody, but that these elements made the buyers of the token believe or would have a reasonable likelihood of believing that they could turn a profit, thus making the sale into an investment contract, and what they're doing, all investment contracts under federal law are considered securities. And just to get a sense, because you get into these conversations, well, no, mine's a security token. I'm sorry, it's a utility token. It's not a security. Well, unfortunately, what the SEC tried to really do is dissuade us of that magical line. And just to give you an idea, the Howey test, which I believe is 1942, had to do with lemons and a lemon grove. A lot of utility there. So what really it becomes is this question about the team that's issuing the token, if they're selling to buyers, first of all, they're in the United States, or they're selling to buyers of the United States, whether or not those buyers believe that, based on the white paper or other communications or what they say, frankly, at a panel like this, people, the buyers like you, are going to believe that, there might be something profitable, or whether or not the only reason that you might buy this token is the same reason you might buy a piece of Intuit tax software over at Fry's, because you're going to plug it in and use it. So that's one. When we're looking at these things, though, securities, everybody's so focused on it, they forget about a whole bunch of other areas of law. You have to look at federal, the federal regulations under Treasury Department and FinCEN, whether or not you need to register it as a money services business based on how it's going to operate. And then, unfortunately, in the United States, you have 50 states and 3 territories with differing degrees of money transmitter licensure requirements that you may need to consider. Then, of course, you've got your general consumer protection laws, both state and federal, and some other bits. So I wish it was easy. It's not. The good news is that it is this really interesting. I've seen this. I helped investors in Mastercoin, which I think everybody points to as the first one in 2013. It's this amazing way to bring people into an open source project and create a community. It is. And I think one of the big problems for regulators isn't so much that it really looks like a security. The problem is it really sometimes looks like securities fraud. And that makes them want to be active in the area. They can also wait quite a bit. When there's been something similar like this that's been in the past, they put out their warnings and whatnot, but they really took really serious actions only 2 or 3 years later. That said, that's not a reason necessarily for me to drive you to the airport. It's an option. I've done it with clients. It's a good reason to be very careful and thoughtful about how it is that you progress and structure things.
And how you're going to describe it later. I mean, it takes them a good 18 months to bring a claim, and they are thinking about which cases they want to take. I mean, Munchie kind of gave them a great opportunity to do exactly what you said.
So, Kelsey, as a tax attorney, you might be our favorite or least favorite person on this panel. There's a lot of tax issues when it comes to doing an ICO. Can you give us a quick overview of what people should be thinking about, right? Because traditionally when you raise money, you don't really pay taxes on it, but now if there's a utility feature, you might have to pay some capital gains tax. What are the different issues we're battling in this space?
Yeah, so there are issues on all sides of an ICO transaction from a tax perspective. And unfortunately, it's not a lot of good news, although I can tell you one thing that you would benefit from if you're getting into this space or if you're in the space already is to talk to a tax advisor and try to figure out how to plan intentionally in a way to minimize the tax costs of what you're doing and at least be aware of what your obligations are. But to give you an idea of some of the issues here, from the company's perspective, if you're raising capital through an ICO, typically if you raise capital by selling stock, preferred stock to a venture capitalist or friends and family, that kind of transaction, when you raise money, it's tax-free to the company. It's capital contribution, it's very well settled law. If instead you're selling tokens or you're selling something that might become a token, it's most likely going to be treated not as capital contributions but as revenue. And revenue is taxable unless you spend it. And if you're raising $10 million and you can spend $10 million in a year, that's going to work out. It's all going to wash because your expenses will net against your revenue. But some of these ICOs that went last year raised hundreds of millions of dollars, and there's just no conceivable way that they can spend that money in a year. Sometimes you can do it within 2 years. So the problem is, if you raise $200 million, the tax rate on that as a corporation is going to be 20 to 25%. So all of a sudden you have to pay the government $50 million. And it really hurts if the value of what you took in, say Ether, for example, plummeted. I mean, that really hasn't happened a whole lot, but if you take it in, it's worth 200 million, and then when you have to pay the government, it's worth half of that. Government doesn't care. It was worth 200 when you got it, and that's what your tax bill is based off of. So there's a lot of planning that goes into this on the company side, and that has led a number of companies to try to set up offshore structures, which have a lot of their own dangers. If you're a US company and you really have no business going to the Cayman Islands, it's not necessarily a good idea for you to have your first trip to the Cayman Islands to set up a tax subsidiary there. It's just generally not a good idea, and usually you have a lot of other stuff going on with your blockchain technology that you really need to focus on your business, and you shouldn't focus on an offshore subsidiary. That's kind of my personal bias.
Greg, it looks like you have something to say.
No, one question, because this is something we're thinking about now from an investment perspective. What do you think is likely to happen in early April when all of those founders, US founders who raised substantial amounts of money last year, all of a sudden realize they have this giant tax bill due?
I think there's a real reckoning coming, and it may not be in April, because I think a lot of people either are unaware of this or they're being intentionally blind to it. I think companies that have raised capital, if they're well advised, they will have to pay significant tax liabilities. The other side of this, where I think there's really rampant ignorance, is if you're the investor investing in an ICO, you're probably not paying cash. You're probably paying Ether or Bitcoin that you bought for 10 cents 2 years ago. And when you do that, sorry, I talked too long. I guess it shut me off. So if you're the investor, the answer is, no, I'm just kidding. If you're the investor, and let's say you invest $1 million worth of Ether and you bought it for $100, well, again, if you were investing dollars, that'd be tax-free. But if you're investing Ether, that's taxable. You just bought something with Ether. And I think a lot of people who bought Ether or Bitcoin really low, they spend it, they just don't realize, well, that's a taxable transaction. It's as if you sold it. So then those people owe money in April. And last year, a lot of these transactions, there was a reasonable position, but not clear, that if you swapped out one coin for another, that qualified for what's called a like-kind exchange under, I don't need to tell you the section, but under like-kind exchange rules. The problem is the tax reform legislation that just passed in December shut that down for everything outside of real estate. So it's very clear now that you can no longer trade one coin for another tax-free.
So you hit on a very interesting issue a minute ago, which is there are all these ICOs from 2017 that went out, they did their ICO or their sale, and they're kind of in legal or regulatory purgatory right now from many perspectives, a securities perspective, a tax perspective. Do you guys have any quick insights on the issue? What are they going to do? They're stuck in legal and regulatory limbo.
I guess I don't know that it's quite like purgatory. You can actually, some things like tax you can fix by paying your taxes. You get somebody who can figure it out for you. Other things, it's very, 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 very hard to fix a securities offering. In retrospect, I don't know that many, if they didn't try to structure it going forward, I don't know how much effort's going to be given to try and fix it in arrears unless a regulator actually knocks on the door, which will happen to a certain degree.
Yeah, I mean, I have two ways, because we get asked this question quite a lot, actually, and I have two sort of answers for it. One is, really, if you tried to do the best you could not to commit securities fraud, then you can point at your actions. You can't change the actions because they already happened, but you can point at them and say, we tried to comply and we did the best we could following the rules as we understood them at the time. So it's not a very strong answer, but it's the answer you have if you're in one of these companies. And the other thing I would say is that they're really not looking to take out innocents. I mean, they don't have a lot of resources, so there's a hiring freeze at the SEC, so they're probably going to try to go after the bad guys. So you should really be concerned if you're one of the bad guys.
There was another question that I think, Greg, you touched on real quick, which is in 2017, we saw a lot of these ICOs go out and do very interesting legal structures and go off and form foundations in Switzerland and Gibraltar and the Caymans and Panama and all these different places. And yet, like, for me, in my heart as an attorney, I like to keep it simple, right? Like, when you look at a traditional startup, it's a Delaware C corporation. Where are we seeing the shift on that? Is Delaware about to lose a lot in taxes and all this other stuff?
Well,
Is
I think
the U.S. about to lose a lot?
well that touches on a larger issue, which is which is jurisdiction shopping, right? So if the U.S. isn't going to take a sort of leadership position with respect to this new asset class, then companies are going to shop for jurisdictions at will, right? And Gibraltar and Japan and Estonia and others are all sort of leading the charge into new favorable regulatory regimes that will attract this sort of level of technology, or this type of technology, this type of offering. I think if you look at historically, you look back 30 years at sort of the early days of the internet, if those companies chose to be developed or chose to develop somewhere else because the U.S. did not have favorable laws, it would have a monumental effect on the U.S. economy today. Mm-hmm. And I think the regulators are generally aware of this, and certainly Congress, or some members of Congress, are more aware of this, and they are, if they have foresight at all, which most of them we like to think do, acting in a way to ensure that the U.S. is not, a jurisdiction of second or third or last resort.
Well, I've heard, I don't know if Steve or Adam, if you know more about this, but I've heard that Delaware is actually innovating and that they've got the first blockchain-based stock system.
They do, yeah.
Yeah, that they're offering out for people to use. I don't think we've had any clients actually use it, but they're experimenting, and it wouldn't surprise me if before long, Delaware in particular, you would issue all of your shares on a state-backed blockchain.
They actually have a whole blockchain initiative going on there right now, so it's very interesting. All right, so let's talk a little bit about the future of blockchain and where the U.S. fits in. Is that, with all the regulatory uncertainty, I guess you could say, that's happening today, how do you hope things will pan out? What can we possibly do? Or do you think regulations are going to stifle innovation? Anybody?
I don't think, I'd be very surprised to see a lot of regulatory change in 2018 in the United States. The number one thing that could really change things is either the Office of Comptroller issuing a new sort of banking tier for companies in fintech, because actually the way that our financial regulations are, they're not just stifling blockchain efforts, but a lot of fintech across the board. And there's a proposal by the federal comptroller to actually create sort of a new banking category. And what that would give us is a single banking license federally that would give preemption in the states and would be hugely helpful. Would give investors a greater idea of how their startup company would roll out and actually address regulatory issues, and it would be a lot less expensive. They are being sued, the federal comptroller is being sued by a collection of state AGs and associations in order to try and stop that. So it's not, I don't know how much optimism I'm supposed to have. Other than that, you just don't, there was a lot, with the advent of the internet, and maybe it's because it touched more people faster. The internet spread out fast in 94, 95, 96. And because of that, I actually was representing the largest ISP in the country, and we were getting sued by the Church of Scientology because we had their secret documents on our servers as part of Usenet groups. And it turns out that they won. And Congress reacted immediately to that and passed new legislation, which literally, if it were not passed, we would not have eBay or Craigslist or pretty much any of the sites that you like to use because of state-level liability and issues with copyright laws. I'm not seeing that. You also had this problem where this is the 90s, right? We couldn't really export hard cryptography. It used to be on the munitions list, much like you would be, I don't know, selling atomic bombs. And this was the Clinton administration. You kind of would have thought they would have said, you know, let's keep the internet going. But this was a real fight for a while, and it looked like American companies were going to be second class because we just couldn't create good firewall good technology. And it changed, but you know, because that one took a little bit longer, but it changed, and I think it's the reason why we have the quality of companies today around the United States in this field. I haven't been seeing the same momentum behind this and the same concern, either for fintech or for blockchain specifically. So I don't mean to be pessimistic, but
I mean, just briefly, I mean, I can't remember who it is that said it. I mean, you might remember who said it, but I've heard it said, I hear the herd coming, meaning a lot of new investors are going to come into the market, and they haven't come yet, and it's because they don't know how to do it yet. And there's other regulatory regimes that apply. And so I think it's just going to be a really interesting time because as there's more happening, we're going to see more. Because I agree with you. I don't see a lot of, nobody's going to really rush to do something immediately in 2018. I don't think, and I think there's a lot of concern about, you know, how is it going to develop, and the fear of, I think the fear of companies running offshore is very real. I mean, blockchain is fascinating in part because it's radical capitalism, and so the distortion that regulations cause, you can see immediately companies moved to go to these different countries, and you get to actually see that play out in reality, and it's really fun to watch for me.
Fun for you, not for everyone else.
I would add, I'm a generally pessimistic person who's a huge fan, so you know whatever I'm saying, add it, you know, be slightly more optimistic than that. We are seeing a lot of Congress people take up the charge. We're seeing people running for Congress, including in Orange County, who are, you know, very tech forward. Exactly, and so keep your eye on that. Yeah, look for Congressman Ford and other people that are really understand these issues, are really interested in it. You see jurisdictions like Texas that are both very, very, I would say, fintech forward, but also they've been doing securities enforcement against ICO, so they see the positive, they see the negative, and they're very, and that kind of stuff can break out. States compete with each other for business, right. And you know, things happen within the federal government when you least expect them in a good way.
Yeah,
but it takes, frankly, your interest and people working very, very hard, and a lot of people with, you know, smart people, frankly, with money also letting themselves be heard, and then the population going, what do you mean I'm not going to get that? I really want the law to change so that I can get this sort of thing that I'm experiencing that's really making a change.
Yeah, that's very true, and just something to remember is that sometimes these regulatory changes are led by the states because they are competing with each other for more business.
Yeah.
And to Adam's point of people wanting it and the system changing so that they feel like they're not getting it. So 6 or 8 months ago, almost every ICO was a very small private pre-sale to, you know, accredited investors, followed by a large public sale. But because of the way the laws are in the US, what you see now is almost exclusively a very large private pre-sale to investors, and then often a very small or no public sale, which means the current legal and regulatory regime in this country is preventing most people from being able to participate in what might be the greatest wealth generation event of their lifetime. So I think if people are loud about their desire to participate in this, it will lead to change much more quickly than my pessimistic friend here may think.
Do you hear that? He wants you to go talk to your Congress people and your elected reps.
You know, it's very true, and another way to look at it is they basically shut off all company exits except for very large shoot-the-moon IPOs or selling your company to another company. And I think that was a distortion of the market too. And that's been that way for about 15 years. It used to be that you could invest in public stocks. It turns out that people do want to do that. And that's what we're basically building a new stock market around the side of the old one, which doesn't work for Main Street investors anymore.
I know Howard has interesting opinions on that. He's on the next panel. So we have a couple minutes left. I wanted to take audience questions. Please, questions, no comments, and keep the questions short. Questions short, yes. What are your thoughts on airdrops from a legal regulatory perspective?
This is really a question for our tax expert over here, I think, more than anything else.
So airdrops, my understanding, that's when coins fall out of the sky into your wallet. And there are a couple of different ways to look at that from a tax perspective. Probably the IRS's view would be that that's income. Like if you catch the 500th World Series, home run, that's in theory, that's taxable income. Does anybody report it? No. There's another view out there, and this is a friend of mine at Deloitte. He's written a paper on this. Tax papers, I know you guys are thrilled. But there's an old line of cases involving book reviewers, where I'm a book reviewer and I get thousands of books that just get mailed to me, and are they taxable income? And there's case law on this, and that says, well, no, unless you exert ownership and control over the books. If you take them and you put them in your library, or you try to give them away. And so, he's analogized that to airdrops, and I think that makes a lot of sense. That, look, if you have a wallet and some coins show up in it, that shouldn't necessarily be taxable to you, but if you go and you do something with them, like you spend them, or you move them around, or you give them to somebody, then that probably will trigger the taxable income. That's probably the middle of the road view on it.
Quick question over there. The question is...
So the question is hard forks, which until very recently I thought airdrops and hard forks were the same thing, but I know they aren't. So when Bitcoin Cash forked off of Bitcoin, right, what happens? Well, again, there's the theory that it's found money and it's taxable when you receive it. There's another theory that, well, that's just a division of property that you already owned, right? If you own a house and you divide it into 2 houses or to 2 condos, you're not taxable on the second one. And so there's that sort of analogy. But again, this is a gray area, and you're just trying to sort of go.
Sorry. There's so many questions. I'm just, maybe talk to him afterwards. Yes.
So the question is, what sort of barriers are there to people who want to buy tokens or blockchain assets in ICOs? And I'm assuming you're talking about legal barriers. None. I shouldn't say quite none, but really our laws are to protect the buyers. The laws are to protect investors. Yeah. So it isn't like, well, I bought tokens in an ICO and you go to jail or something like that. It's really about the issuer and the promoters and the middle people and the marketers. The laws and the regulatory efforts are on them. Now, you could get into, I suppose, trouble because problem is you say something like that on a panel. The guy goes, okay, I'm buying $1 million worth of tokens and I'm selling $1 million. Well, now suddenly you look a lot more like a middle person, right? And you can be doing other things. But generally speaking, it's just like you buying shares of stock from IBM. Generally speaking, you've done nothing wrong.
And I will add on to that, there are laws that do allow you to sell to the crowd, non-accredited investors. The only thing is that you have to abide by certain things. So for example, regulation crowdfunding allows you to sell to non-accredited investors, but you can only sell up to $1 million every 12 months. Regulation A+ allows you to sell up to $50 million a year of securities to non-accredited investors, but you have to go through an entire qualification process that usually takes at least 6 months to a year and is quite costly and expensive.
And none of those are good for the companies issuing the ICOs.
Yes. It does come down to a philosophical decision. A question from this side, yes.
As a U.S. investor, if you have money on a foreign exchange, say Hong Kong or
Yeah,
Very
so this is an area that I actually don't spend a lot of time in. My understanding is that generally you would, but I've personally not researched that one, so I wouldn't take that as the truth.
I was actually going to ask about that HR 2930 and the Jobs Act, and my impression it was 1 million, and there's a level of 2 million if you're on it.
So
But the question, if you had something that became larger, do they view it as plain, simple circumvention if you create additional child companies that participate?
So the question is, under regulation crowdfunding, which I mentioned earlier, you can raise up to $1 million from non-accredited investors. Can you just create all these different companies? And the answer is actually no. They attribute it back to, even if it's all these different companies, they look at who owns and controls those companies. And so if it's the same people or the same person, your bar is $1 million a year.
So the same as IRS consolidated.
But on Reg A Plus, what you have now is that they call it Reg A Plus. They put the plus because we got more. In 2015, it's still Reg A. The difference is now you've got up to $50 million that the same company can raise once every 12 months. And you know, it far surpasses anything you can do under regulation crowdfunding. And also,
Sorry, we have literally time for one last short question here.
So on policy, I've done some policy writing in DC and how you go about doing that. Is that happening among the legal and the tax community to push in what they want it to be? And just kind of going down the idea that blockchain and crypto should be not controlled, or the big entities coming in and writing that policy and pushing it?
there are and have been, I wouldn't say that since 2013, but certainly in 2014 and 15, organizations like Coin Center and Blockchain Alliance and some others that are trying to do exactly some lobbying, some educational efforts, and with some success. Certainly on the education front, which is really helpful. Yeah. Private efforts, I don't think I can speak to that.
Yeah, I would say just go look at the Senate hearing, see who was there, see who was contributing, see what papers were filed by them, see which senators were asking the questions, and that's going to give you a good sort of roadmap of who's writing about it. And I think you're going to be surprised at how few people are writing about it. It's a problem, if you ask me.
And I will say, as someone who used to work in the federal government in regulatory affairs, and having had to read all the comments that people were writing in, there is actually someone in the government whose job it is to sit there and read all and categorize all the comments. So if you guys are, commenting and contributing, just know that unfortunately or fortunately, someone is actually reading it. So that's it for this panel. I know there's a lot of questions. Hopefully our panelists will be gracious enough to step outside and you can pepper them with all your cryptocurrency tax questions. Thank you so much.